For the first quarter century of their existence, defined contribution plans rarely served as catalysts for lawsuits. But things began to change in the early 2000s when lawyers realized that plan participants did indeed have the right to sue over things like breach of fiduciary conduct. More recently, litigators have been targeting fiduciaries for oversights, such as allowing excess plan-related fees to eat away at participants' savings. These days, plan participant lawsuits carry an even greater risk of financial repercussions than many IRS or DOL violations. While this can be intimidating for plan committees, the best defense is to stay focused on providing a good plan while living up to fiduciary standards. These standards are outlined in ERISA, which specifies a set of obligations that all fiduciaries must uphold. These include things like making decisions based solely on the best interest of the plan's participants and beneficiaries. This is the heart of a fiduciary's duty. So it's essential that you're never afraid to put your plan participants' interest over those of your company or employer. Additionally, it's your committee's responsibility to abide by the plan's governing documents, avoid any potential conflicts of interest, and act prudently to diversify the plan's investments in order to minimize risk. Managing the plan's costs is an incredibly important committee function. Excessive fees have become one of the most common complaints in plan participant lawsuits, along with inappropriate investment choices and self-dealing. Aside from following the rules to the letter, one of the best ways for fiduciary committees to protect themselves is to hire their own attorney. Many committees work with lawyers who were originally hired by the plan sponsor, which is not something I personally recommend. Using plan assets to hire a lawyer specifically for the committee is a great way to avoid conflicts between the employer's interests and those of the plan participants. Additionally, your committee should insist on obtaining fiduciary liability insurance, which covers you personally against claims that you have breached your duties. Note that this is not the same as an ERISA fidelity bond, which is required for all plans. Scrupulously documenting every decision your committee makes and why is also an invaluable way to protect yourself. Often, the first questions that fiduciaries are asked in lawsuits concern their decision-making process. When questions come up regarding decisions your committee made years ago, properly recorded meeting minutes can make all the difference. In addition to meeting regularly, your committee should maintain written rules of procedure, terms of service, and appointment processes. Be sure to include and abide by clear policies regarding how to avoid excessive plan fees, inappropriate investment choices, and self-dealing. Ensuring that every committee member understands the dangers of these common lawsuit triggers could save your company millions in legal and settlement fees. You should also be aware that violating ERISA standards can result in civil or criminal charges by the Department of Labor or Internal Revenue Service. Civil actions can result from things like failure to operate exclusively for the benefit of participants, failure to properly select and monitor the activities of the plan's service providers, non-discrimination testing, or taking adverse action against any participant for exercising their rights under the plan. Criminal violations usually involve things like stealing or embezzling plan assets, lying to an enforcement agency, or taking kickbacks. Each of these measures should go a long way toward mitigating your committee's risk against legal action. In the end, the best way to avoid trouble is to understand what it takes to do a good job, and then to do it.